I believe the bell worked. There it is. How's that? How's that for timing? I'm going to call the June 4th, 2026 Election Board meeting to order. We're going to modify slightly. I'm going to ask Kylie to update some Election Board minutes because we don't have them all yet.
Yeah, so we were talking about it within the office and have decided that it would be better to hold off on the minutes until all of them are completed, and then we just approve them at the same time so that we are up to date and don't have part of them now and part of them in July. And then in addition to that, I do have a couple of upcoming important dates that are coming up on us. One of which being June 18th, 2026 at noon. That is the deadline for school board filing. Then June 30th, 2026 at noon is the independent and minor party candidate petition filings. That is your deadline to get your first set of petitions within our office. And then July 3rd, 2026 at noon is the last day to fill any ballot vacancies. July 6th at noon is write-in candidate filing. July 15th at noon is independent minor party candidate filing, and then July 15th at noon is candidate withdrawal for the general election.
That was a lot.
It's all in an email going to you guys.
Thank you.
So
I don't write that fast anymore. But thank you.
You're welcome.
All right. And then we will adopt our agenda, unless there are questions. We'll adopt the agenda. Starting with what we have as number 4, establish the hearing procedures. And we'll go from there. And Molly is going to take the lead on this for us.
So for the election board's review, I drafted a resolution establishing hearing procedures, and the resolution currently states that it's specific to the hearings held on today's date, but if the board so wished to amend it, they could amend it to make these the procedures for any future candidate complaint hearings. I drafted this because it was advised by Indiana Election Division that it is recommended to have some procedures in writing prior to the hearing. So I don't plan on reading the resolution unless you would like me to, but I was going to summarize it. Is that okay?
I would, yeah, we've read it, so
okay.
A summary I think would work.
So the procedures are that the election chair would call the hearing to order. Then any individual wishing to offer testimony would have to be administered an oath. The election board would then recognize the complainant. The complainant may present evidence and argument to the election board for no more than 10 minutes unless the election board votes to allow additional time to the presenter. If the complainant is not present, they could and submitted any written correspondence that would be read at that time. And then it acknowledges that the burden of proving the complaint falls on the complainant. Thereafter, the board will recognize the candidate who's in question. The candidate may present evidence to the board for no more than 10 minutes. However, if any extension of time afforded to the complainant, if the complainant was given more time, it is recommended that the candidate in question also be given the same amount of time. Evidence or argument presented by the parties should be directed at the election board and not other parties. This, in essence, wouldn't allow the candidate or the petitioner to cross-examine each other. The election board may ask individuals who offer testimony questions. However, if any questions is posed to the complainant or the candidate, it would not count against their time frame. If the complainant or the candidate offers documents or evidence, a copy must be provided to the election board for the record for the hearing. And then upon conclusion of the evidence, the board will close the hearing and therefore thereafter discuss how to resolve the complaint. That is the procedures as written.
Here, do we need a motion to accept this?
I was about to add, do we need?
Please.
I move that we pass the resolution adopting procedures for a hearing to be held on June 4th, 2026.
Any discussion? You need to call a roll, or can we do voice vote?
This might be one where a roll is not required, but I might recommend it.
Okay. Ashley, please.
Nicole Brown? Danny Shields?
Yes.
Penny Gibbons?
Yes.
So now that we've adopted procedures, I think what's next on the agenda is moving forward with the complaint filed by Ms. Wheeler against Mr. Davis. So I can give a brief summary of that complaint. The election board was...
Should we?
I think we could either do it either way. We could officially call the hearing to order, and then I could administer the oath and then give a summary. The way that flows is kind of up to you.
Okay, then I will officially call the hearing to order.
Do you want me to go ahead and proceed with the summary? Okay.
Yes, yes, please.
A letter was, or an email was received from Ms. Karen Wheeler on April 28th, 2026 that outlines 1, 2, 3, 4, 5. It looks like 4 potential election violations. And in summary, that includes violations pertaining to campaign signs without the required disclosure, electioneering inside the chute, following a voter after voting, and potentially misleading representation of legal credentials. A copy of the complaint was provided to the board, as well as Mr. Davis, who received certified notice of today's hearing, along with a copy of that formal complaint. Unless there's questions on that summary, I think we could proceed to the complainant providing or addressing her complaint.
Ready to proceed if you guys are. Yeah, I think we're ready to proceed.
Is the complainant here and would like to address the board?
Good afternoon. I am
And Ms. Wheeler, before you jump into it, I'm going to administer an oath. So can you please state your name?
Karen Wheeler.
And Ms. Wheeler, do you swear or affirm that the testimony that you're about to provide to the board is the truth?
I do.
And then for the record, Ms. Wheeler has affirmatively taken an oath.
And now I proceed? Okay. So I had the opportunity to see Joe Davis pretty much every day during the election, early voting, because I work in that building, and I would come outside and I would see him. And pretty much every day, I really can't think of a day that it didn't happen, but I did not have the disclaimer on his signs in the beginning, and that he would very often go into the chute. He would follow people to the door. He would also follow people afterwards and walking them to the car or toward their car. I saw him different times blocking people so they could not even get out of their car easily. And for me as a woman, that would be intimidating. No matter where you're at, you just don't want anybody, but especially a man, standing there that I can't even open my door without him moving. And I think the voting can be intimidating enough. You don't need to have somebody that's stopping a person to even get out of their car. I don't think this is illegal, but it was an irritant that he would sweep the sidewalk in the parking lot pretty much every day, that there would be a dust bowl. It would be a irritant if I was a voter coming through there. I mean, when I walk through, it would make me cough, or you don't want to walk into all this dust. He claimed that he was a practicing jurist at law, and I'm not really for sure what that is, but it didn't seem like it was accurate, or it seemed confusing at best. He would also just do things that were kind of bizarre, from brushing his teeth on the sidewalk. And so I thought it was I think Monroe County is a great county, and we really want to have the most accurate voting day that we have, from our early voting to election day itself. And this just did not reflect, I think, what Monroe County stands for. I think that would be probably all. Probably one thing, too, that was just a little bit different than this, that probably even in all of that, I was probably surprised that there wasn't any action toward him. And maybe the procedure is that somebody has to come in and complain. But I was kind of surprised that Election Central didn't do this, because if I saw it, they saw it. It took a long time. It was weeks into it, and I thought it should have been handled much sooner. And that's probably it.
Just to answer that, respond to the last comment, short of calling the authority, the Sheriff's Department, I guess would be, is there anything that anyone in your office or Election Central could have done about this?
We did.
Okay.
So, Kylie, if you want to summarize.
Go ahead.
I'm sorry, the lights on the here keep going off.
So there were multiple in-person conversations before a formal written notice was given to him. It was, I believe, the first Saturday of early voting was when the written formal statement saying that he was not doing things that he was allowed to be doing, and that was after the first two conversations that we had had with him.
And Kylie, is it fair to say you had also called Indiana Election Division for guidance?
Yes, and that's when they said to just go ahead and do a written statement, and then after that to then move forward with law enforcement.
And you had also notified the party chair?
Correct.
So there was nothing that you could have done differently?
Yes, ma'am.
And if I may, since Ms. Ferris has now provided testimony to the board, I'm going to administer an oath. Can you please state your name?
Kylie Ferris.
And Ms. Ferris, is the statements you just made to the board truthful?
Yes.
Ms. Ferris has affirmatively taken an oath.
Thank you. I didn't mean to lead to that, ma'am. I was just asking. And I remember the form that we got where he said, you probably shouldn't be doing this.
And sorry, there was one occasion where I left Election Central, headed back to the Justice Building, that county attorneys who was on his way to deliver the paperwork to Ms. Davis regarding this is what you could be charged with, this is penalty that it carries, and we stopped and spoke on that date.
I'd like to point out to the public, too, that we received copies of short videos of Mr. Davis, and at one point he was in the... Am I allowed to describe the video that was sent to us? Okay. Correctly. And he kept saying, I'm not electioneering. Well, I would point out that there were pictures of Mr. Davis on his yard sign, and so it was very clear who he was to anybody who was coming to vote, that he was, in fact, the candidate, whether he wore a T-shirt or a sign.
Yes.
That his picture was up there for everyone to see.
My question was that he was given notice that he wasn't supposed to be doing.
Yeah, so...
And then the complaint is that it continued after those.
Yeah, so he had come into our office almost daily, stopping in, talking to us. There were times that he would go in through the entrance of early voting across upstairs to then go to one of the restrooms, and we had spoke to him about him not being able to do that and to come around to the main entrance. And after, I would say probably 3 conversations was when I reached out to IED, and then that was that Saturday, the first Saturday of early voting, that we did the formal written statement.
So it seems like it took about 2 weeks before there was anything that was obviously done from Election Central, when it was daily that it was happening.
Were the signs changed? The thing about not having a disclaimer on the sign, the first one I saw had the disclaimer on. It wasn't very big, it may not have meant, I don't, but are you saying that they were changed during early voting from originally? Did I misunderstand you saying that?
Personally, I don't know if I ever saw a disclaimer on there. I don't know if all of them were changed. There were some that I was told were changed,
Okay.
but we're talking at least 2 weeks, probably longer. And I also know that he had been told by multiple people, probably every candidate that was out there would say, don't go in the chute, please don't sweep, don't do this, don't follow the people, please don't, whatever it was. And he continued to do them.
It's my understanding also that the disclaimer has to actually use the word paid for by or paid by, and that was not on.
And it has to be in a certain size font, which I don't remember right now what that is, 12, I don't know.
I was reading the law this morning, things like that, but it has to use those words, and from what I observed, his, later at least in the campaign, did not have those words on them.
I have a picture of one that has his name and his picture without the disclaimer on there if you want to see it, if you haven't.
Molly, can we do that? Can we look at it?
If Ms. Willer is presenting it, yes, we'll just need a copy of it. Is it the picture that you've already provided a copy of?
I'm pretty sure it is.
Okay.
I did not get up close to look at them. I kind of stayed away from what was going on out front as much as I could. I didn't want to get in the middle of it. So I would like to see a copy if that's.
I can just hand this to you.
Sure. Got to make it bigger. I'd like to hear. This is not the tech way, but it'll work. That's probably not the techiest way you've ever seen something looked at, but it got the job done. Okay.
Mr. Chair, there was one instance, and I can't tell you, like, in terms of the first day of early voting or within a week, but I was told that there was someone who had a medical emergency and that Mr. Davis went inside of the chute to assist the person who had a medical emergency. Obviously, it's clear that there was more than one incident. When I heard that, anybody I would think following the Good Samaritan law would step inside to, in terms of priority. So if we're establishing how many times did he violate the chute policy, I could see extending grace that if it was medical. Everything else, obviously, that he was in deliberate.
Well, she said she testified that she saw it happen more than once.
Yes, and I'm agreeing that it happened more than once. But in terms of the inference that there was unwillingness to address the issue, the first issue brought to my attention was that there was a medical issue. And so I did not raise that. If someone had called him out for that, I was prepared to send a grace, because any good Samaritan would not be worried about that if someone were in distress.
So procedurally, I think the question is Ms. Wheeler, are you done with your presentation?
Yes, I am.
Okay. And so at this point, based on the procedures adopted, unless the board has further questions for Ms. Wheeler, we would offer Mr. Davis the opportunity to make a presentation.
I would be fine with that.
Okay. I do not see Mr. Davis present. Mr. Davis received notice of the hearing via certified letter that was mailed on May 15th. He subsequently came into our office last week to pick up copies of the video and photos that were submitted with the complaint. So I do believe he had knowledge of today's hearing, and he's not here. I have not received any written correspondence from him. At Election Central?
We have not received anything in writing. He did stop by today.
So at this point, it doesn't appear that Mr. Davis is here to present evidence, and so procedurally, you could move with closing the hearing and deliberate.
No, I was going to say, I can't see everybody that is online, but I also do not see a hand raised. That's what
I do not see Mr. Davis online. Appears that Mr. Davis is coming in the building right now.
Well. I don't see any reason to recess for 2 minutes. If he comes directly upstairs, we'll just...
It may be beneficial to recess. That way I can explain to Mr. Davis the procedures that we adopted, because I don't know that he was here for that, and so...
Then I will recess the meeting until we're ready to move on.
So can we say for 5 minutes?
I would say, sure.
Okay, thank you.
1:58. All right, I have 1:58. I will call the meeting back to order. And we're waiting. Mr. Davis is in the building, we believe.
I did have a brief conversation with Mr. Davis and advised him of the procedures, and he advised me he was bringing up more stuff. Quote, I told Mr. Davis we were in recess and that he might have to address the board. He is not present. And for clarity, to address the board to get more time to get the stuff.
If you folks back there see him, we'd like to have, if he wants to talk to us, he should be here.
Mr. Chair, may I?
Yes, please, go ahead.
Excuse me. While we were in recess, I did want to clarify a couple of things with the election supervisor. And so what I understand, and Kylie, please correct me if I am wrong, the guidance that the election supervisor received from the Indiana Election Division was that it is the party chair's responsibility to, for lack of a better term, corral the candidate. The election supervisor did notify the party chair, and no action was taken, which is then why she went and got more guidance in the written. So there were procedurally things, whether or not it was clear to anyone watching, the steps were taken as recommended by the Indiana.
There are times that an officiating career comes in. You know what I mean? No. It was called for 1:30. Everyone in here has things that in their life as well. So, Ms. King, you are. We're reconvened, yes, absolutely.
So now would be the opportunity for the board to hear Mr. Davis's presentation. If Mr. Davis intends to present, I will ask you to take your spot at the podium and I will administer you an oath.
Please, may I have just 5 minutes?
We've had enough time, You can either make your presentation or not. That's your option.
Please, I just need 5 minutes. Complicated.
Well, Mr. Davis, well, at the beginning of today's meeting, we adopted procedures that afford you 10 minutes of presentation.
All right, I'd like to read those, please. I see those. See that?
Is this,
Can we put the clock? Can we just?
you can, these were out. These were available.
Okay, Mr. Davis, I have a copy for you, but it in summary says that the complainant will be afforded 10 minutes, the candidate would be afforded 10 minutes, that the election board could ask questions, that time spent answering questions does not count to your 10-minute time frame. If you offer evidence, you have to provide a copy to the board, and at the conclusion of the evidence, the board closes the hearing and therefore will after discuss the complaints. So at this time, I think I have a copy here right for you. And at this time, I think the board is indicating that they are moving forward to the candidate's opportunity to present. And so if you'd like to make a presentation, can you please take the podium so I can administer your oath, and then your 10 minutes will start. Here are the adopted procedures, sir. Do you please take the podium so I can administer an oath? I think the board has not in recess, so they're asking you to proceed with the hearing so that I can administer the oath.
Mr. Davis, this is not helping your case. Okay?
I'm just 5 minutes and I asked for this.
You've
so
had,
read it out.
it is time for us to continue. It is highly appropriate. You have the same rules everyone else does.
Without allowing me an opportunity to read it.
It was read into the minutes. We got it at 1:30. We didn't see you around there at 1:30. So print it. You didn't have to print it. She has copies of it.
Okay, but you adopted this while I wasn't here. When you were in recess, this wasn't given to me. I didn't have an opportunity to read this.
Would you administer the oath, please, ma'am?
Mr. Davis,
If you need to be at the podium to administer the oath. You need to be at the podium so she can administer the oath and we can continue.
As far as I'm concerned, this is cutting into his 10 minutes.
Are you doing the timing?
I will start timing.
Start the 10 minutes.
I'm ready to take the oath. So that's going to cut into my
Your 10 minutes has begun.
Well, I swear to tell the truth.
Mr. Davis, you have to be in a microphone.
To the law enforcement, would you please remove the things that could be construed as weapons from the room?
No, these are not weapons. These are my
Those
tools
can be
that I
used as
need for
weapons.
exhibits.
I want them moved.
No, these are my tools that are my exhibits. You're looking at my tools. These are my exhibits. They are not weapons. This officer has already talked to me and said, please don't turn anyone's digits off today with your printers. And she didn't say that. She just said, do not approach anyone within your. I am not going to. They are there. They're going to stay exactly where they're at. Okay.
Okay, the oath. Mr. Davis, do you swear or affirm that the testimony you're going to provide to the board today is truthful? Mr. Davis?
Pardon?
Do you swear or affirm that the testimony you're going to provide today to the board is truthful?
Sorry, what was that?
Do you swear or affirm that the testimony that you're going to provide to the board today is truthful?
Yes, I do. This is to.
For the record, Mr. Davis has now affirmatively taken an oath and may proceed with his presentation.
Okay, hello. My name is Joseph Bradley Davis. I ran for clerk as Joe Davis. I was at every early voting session from the beginning all the way to the end. I camped out basically at the area where early voting takes place, and it was a shambles. There was debris everywhere, all over where the handicap parking was a mess. So I took my time to clean up the property, clean up the hardscape around, to prune the trees, to make it hospitable so that voters could come and enjoy their day of voting instead of walking through a litter covered environment with gravel that was hard to walk and branches and debris everywhere. Okay, so I cleaned this up. I brought some of the rock and gravel that I cleared off of the parking lot in the area where the handicap parking was. I took care of that place. Unlike my other candidates who were around, they just candidized in their chair for the most time. So at any rate, it's been alleged that I have violated several items. According to Karen Wheeler, and as written up in the, and could I see some sort of a timer so I know where my 10 minutes are? I'm not going to turn and look at this. I'm sorry. I need to see something where I'm looking this way.
I can give you an audible alarm if you'd like, Mr. Davis. At what time would you like me to, like a 1 minute warning and a 30-minute second warning?
At 5 minutes, 3 minutes, 1 minute, 30 seconds, and 0. Okay, and can we please back up the clock a little bit for this housekeeping?
No, we're moving on.
Okay, first off, I want to say that Penny Githens should recuse herself from sitting on the board, and someone else should fulfill her role, because she is a biased individual who is not going to give me a fair hearing. Especially, she has had a hand in 2 of these alleged allegations coming from Karen Wheeler. One of those is the sign. She was scrutinizing my sign incredibly. She and the other whispering cabal, which is what I call them, Karen Wheeler, Penny Githens, Tree, Martin Lucas. There was another woman with frizzy gray hair. She was in one of those videos. Another guy, they were always whispering about me while I was cleaning up around the place. And obviously it was, trying to conspire and come up with what they could do to bring me down. because they are scared, especially after got 21% of the vote, which is very good for a first-time primary candidate.
You have 5 minutes remaining.
Okay, so at any rate, she scrutinized my sign, this sign right here, okay, and said that it is not compliant with the disclaimer. I'm sorry, but this is compliant with the disclaimer. According to Indiana law, this font 12 or more, and it is actually, this is more like it's way bigger than, I don't know, it's like a 16. That is an exhibit. But this is the example. They have the same size font right here, paid by Joe. By Joe, right?
Doesn't say paid by.
It says
Oh,
paid
right.
by Joe.
Okay,
It says paid by Joe. This
Okay.
is the new one.
I see that.
This is the old one. This was approved last election. I ran as a right. Okay, and I put these stickers on there last election, and evidence was scrutinized. The picture that I received, packet doesn't even say who took the picture, as well as the videos. It didn't say anything about videos. That's when. Okay, so back to these issues. All right. Penny should recuse herself because, there should be an alternate.
You have 3 minutes remaining.
Okay. Penny should recuse herself. There needs to be a different alternate because she also, too, accosted me on the early voting day when I was telling voters that I am a practicing jurist at law. I have filed 8 causes or filed into 8 different cases. 7 of those are my own cases. 3 of them have gone to appellate court. I am a practicing jurist at law. You are looking at just a smattering of my filings right here, my law books. Many more, twice this amount of law books are at home. 3 times, actually. I just brought some of them that are most relevant because I'm working on filing for the appellate court right now that's due today. Okay. I am a practicing jurist at law. I never misrepresented myself. And Penny Givens stood there and told me every time I said that, she was going to stand right next to me and she was going to tell those people that I was misrepresenting myself. And when I told her what it said in Black's Law Dictionary, what a jurist is a person who knows where to find the law and knows how to find the case law that gives it its finer detail, and that is what I am. I am a trained jurist at law, and I have been practicing. I have now over 6,000 hours as a pro se litigant, as a self-counsel. I am here as my own counsel before you today. And so it continues. Okay, so Karen Wheeler wrote that.
You have 1 minute remaining.
Okay, Karen Wheeler wrote that I had been talking with voters after leaving the voting site. That's true. I have many friends who I talked to and walked with after they left. There were also people who I missed who didn't go in, and I wanted to make sure they knew who I was because I want
30
them.
seconds.
I want them to vote for me in the fall, and so I broke no violations. One of the video in there, another video in there, according to shows that I am sweeping in the shoot area yes, that was after a bunch of debris and grass, after a rain had fallen. I also did some pruning, but that was before 8 a.m., before the polls opened. So there was no evidence in there of me running through the chute or doing
is up.
anything like that. How much time?
That's the expiration of your time.
Okay.
Okay, one more thing I want to say is that I have witnesses that I wish to bring forward, and they're going to need some time here. I would like to confront Karen Wheeler. I would like to confront Tree Martin Lucas because she took at least one of the videos, and Karen Wheeler wrote these statements, and so I want to ask her where she got her information, and I want to ask who took and talk to whoever took this picture of my sign. I need to be able to be allowed to confront my accusers or speak with them so we can get more clear information about what is being alleged
Mr. Davis,
here.
just a second, please. You may not completely understand what we're doing here today, and I understand that. What we're doing today is determining whether or not there is cause for us to push this along to a different level of people that work on it. We are not in a position to make a finding of guilt nor innocence of any of this, nor are we in a position to determine whether some fines or something would happen. We are not in that position. We are not in a position to have to cross-examine witnesses here. That was part of what we talked about earlier.
If I may, Mr. Chair.
please.
Mr. Davis, in the procedures adopted, it says that evidence or argument presented by the parties should be directed at the election board and not other parties present at the hearing. The procedures also afford a 10-minute time frame for the candidate and complainant to offer evidence and argument. So unless the board would like to afford additional time to Mr. Davis, as I think that is what he is requesting, the presentation of witnesses would have been within that 10 minutes presentation.
Go ahead,
May I
ma'am.
ask a question? When the date and time, I'm assuming Mr. Davis signed for the paperwork that was served,
I would have to check with the legal office if we got the green card back on the certified mailing, but I do believe that we did. I mailed the letter on the 15th.
Mr. Chair, I raised that because
If I may, the letter does specifically state that the hearing's at June 4th, 2026, beginning at 1:30.
that was exactly my point, Mr. Davis, in terms of no one is trying to impede your right to bring evidence, call witnesses, or anything like that, but we all had notice that the meeting started at 1:30 today. And so you took time, you were not here when when the resolution was read. Had you come when notice was given, you would have heard the rules, so to speak, for today's hearing. So to kind of hold that over us feels a little disingenuous to me. Fair, sir.
Yeah, I think that's fair.
May I interject, though? I tried this morning to get a hold of the agenda from County Legal. They directed me to Kylie Ferris. I went to Kylie, and I asked her for the agenda, and she directed me back to Molly. And so without having the agenda, I had no idea when my presentation would be. If this were, I assume this was a standard election board meeting, and there would be business to take care of. I didn't understand that it sounds like it's a special election board meeting. Then it's not a regular election board meeting.
This is
that
our
correct?
regular meeting. This is our regular meeting, yes.
Okay.
And we voted at our meeting when we certified the election results, was at the time to just do the hearings today at the regular meeting. So that has been May 15th, thank you. So May 15th, that was made official.
Okay, but that no agenda was produced at that time. I, as a presenter, had no idea about how the proceedings would be. I'm trying to understand. I wish this morning to understand more fully how long this hearing would be, because I knew that I would need a substantial amount of time, not just 10 minutes, because this is very complicated. I am being accused of potential crimes, misdemeanors, felonies, fines. This is serious. And it seems like this is just a bunch of trumped up stuff to kind of stop my current campaigning, honestly. But I ask kindly for some more time so that I can speak with Karen Wheeler and Penny Martin Lucas. Not Penny, and actually Penny Givens. I would like to speak with Penny Givens as well.
You're running all around with, I made it very plain a moment ago. Our job today is to determine whether or not we believe there's a substantial reason for us to push this along to either the state police or the prosecutor, and to some extent maybe the state attorney general, to determine whether or not election law violation occurred. Is sweeping the sidewalk maybe a little obtuse to what normally happens? Sure, but it's not illegal. Okay? However, if indeed there were signs that don't meet the requirement for the signs, that, sir, is illegal. And our job is to determine whether or not we want to send this along for an investigation by those who are professional investigators. I taught 6th grade. I guess I was an investigator on occasion that way, but I'm not a professional investigator. Okay? Go ahead.
If I may, Mr. Chair, for clarity, today's hearing's being held pursuant to Indiana Code 36531, which is the investigation of election law violations. That code section says that if a county election board determines there's substantial reason to believe an election law violation has occurred, it shall make an investigation. That's what you voted to do at the last hearing. If in the judgment of the board, after affording due notice and opportunity for a hearing, a person has engaged or is about to engage in an act or practice that constitutes or will constitute a violation of a provision of this title, that title being the election code, or a rule or order issued under this title, the board shall take the action it considers appropriate under the circumstances, including referring the matter to the Attorney General or the appropriate prosecuting attorney. I'm reading that statute because it allows you to refer to the prosecutor or the Attorney General or to law enforcement, but it just says whatever board action the board thinks is appropriate.
So our options are to say there's nothing here and it's dead, or we think there might be something here, and we want to run it up the flagpole, as it were, to people who make these decisions on a professional basis. Is that where we are?
Those would be the options of the board.
Does that make sense to you?
Mr. Chair, if I may.
Go ahead, ma'am.
Okay. A couple of things, Mr. Davis. Typically, it is the election supervisor does present, make up the agenda for the board. She will reach out to each board member to say, this is what I have, and it follows a standard order, calling to order, old business, new business, things like that. Typically, that does happen. That the agenda for this meeting was not made by the election supervisor. We learned, talked 2 days ago, yesterday, we were waiting. I asked Kylie, I said, I don't see an agenda. I had checked my email, I didn't see an agenda, and I said, can you just do the standard one? But after our office closed at 4, we received the agenda for today's meeting. So your not receiving notice has nothing to do with my office because the election supervisor did not. My second thing to you, the meeting started at 1:30 today. You were served notice. We went over the rules of the road, so to speak, at 1:30. Had you been here as we were adopting the resolution for that, we probably could have negotiated more time for you. You get 10 minutes for each complaint, and there's 2 complaints today. We could have negotiated if you were like, I can't do it in 10 minutes for each case, I need 15. Do you understand what I'm saying? We could have negotiated. You were not here. We called the meeting to order. We had no idea even if you were coming because you were not in the audience, you know, or close by. We ended up being told that it appeared you were coming in the front door. So we wanted to work with you. You were not here at 1:30 to work with us. Does that make sense to you?
I'm very sorry. I had trouble printing over at the mill, and I got here as soon as I could. I had no telephone contact to reach out to anyone to announce my late arrival. I'm very sorry. We still can negotiate this. It's not too late to negotiate for more time. It sounded like you said there were 2 counts or charges or complaints, and so there's 10 minutes. I have 10 minutes for each complaint.
That is
You have-
correct.
Yeah, this,
Is the first of
This
the
is the first one.
Which, I'm sorry, that was not explained to me.
earlier in the proceeding, we called the hearing to order for the complaint filed by Ms. Wheeler, and that is the hearing that we're currently in. Once this hearing closes, the board will determine how to resolve that complaint and then open the hearing on the second complaint by Ms. McGarry.
I would like to make a motion that we continue this hearing to 1 week from now, so that these rules and the have some time to be applied, and also to such that I could submit a written documentation to support my arguments, especially now that I know that I need to, I have to prepare 2 cases. One case against the first complaint and now another case against the second complaint. It seems like it would be appropriate for me to be able to have at least 1 week to be able to work on each individual complaint. There's nothing in the original letter that says that I'm going to be presenting my argument against 2 complaints individually. It's looked as if everything was just going to be lobbed together. This must have happened before. Aren't there procedures or policies that could have been shared with me?
Mr. Chair.
Go ahead, ma'am.
May I request that we get the proof of service?
I can ask my office to bring it up. I do believe that we received proof of service back on May 21st, but if you give me a few seconds, I can run down and get it.
That would be great. Because
So we will recess until you can get back up here with it. Did you catch there? You ready? Okay. I have in front of me the signed, I'm sorry, I'm going to call us back to order. I'm so sorry, I should do that first. I have in front of me the signed receipt for the certified mail with this copy dated 5/21/26. And as I'm looking through it, it is exact same, can you see it, ma'am? It's the exact same thing that we have in front of us. So it would appear, sir, that you were given this and signed for it, including the code, the Indiana code, on May 21st.
So, Mr. Chair, my point in that is that if he signed for that on May 21st, do you remember that you signed?
Yes, I do, but I did not receive any evidence at that time. I only received the allegations. The evidence that I received came from, from Molly just here last.
Again, I think you're confusing this as a hearing versus a court proceeding. We're having a hearing to decide if we believe there is sufficient cause or evidence, and I hate to use the term in this, but sufficient reason for us to push these along to the organizations that make these decisions. So that's where we are. So that's why we don't need, the people that make the complaint get to speak, you get to speak, we make that in a succinct 10 minutes issue, which I think is plenty of time for this. If we were in a court of law and you needed 3 days, that's between you and the lawyers and the judge. That's not where we are.
Mr. Chair, and if I may, for
Please.
clarity, the letter sent to Mr. Davis does advise that there were videos. It says, additionally, there are videos provided to the election board along with the complaint. Please let county legal know how you would like to receive a copy of these videos. The videos can either be emailed to you and or provided on a flash drive. On May 27th, I had not heard from Mr. Davis, so I did provide an email copy of the videos. And then Mr. Davis did subsequently stop into the legal department, and I provided him a jump drive or a flash drive.
So for me, Mr. Davis, there was more than sufficient opportunity for you to reach out to an attorney if you wanted representation, to, it's clear in the letter to me that you were aware that there were 2 complaints because parties are named in the letter. And so between May 21st, when you signed for it, up to 1 o'clock today, you had that opportunity if you wanted to make clear to the board or to the county attorney that you required additional time, you anticipated call. And none of that happened prior to, so our time is as valuable as your time. We started this meeting on time, called the meeting to order. Resolution was read and accepted, and you would have been here to negotiate more time. I don't think we're unreasonable. I think if you said 10 minutes is not enough, I need 15. I think that was a discussion, but that discussion would have happened at 1:30. Does that make sense to you?
Given the fact that I wasn't presented, that I also just learned that Karen Wheeler also, she already presented her evidence alleging that I was in violation, and so I have not heard that. I have not been able to ask her of any questions. Obviously, it's very important that.
Again, sir, we are not cross-examining, number one. Number two, since she was the one with the complaint, her 10 minutes came to file it first. Had you been in here, you would have been able to listen to her complaint.
That's my point.
So I'm sorry, sir, this poor me stuff is not wearing well with me. Okay? I mean, I appreciate what's happening here, but I'm like, everybody in here was here at 1:30. Okay? You chose not to be for whatever reason. You know, I go back to some people saying on time is 10 minutes late, and you make your own choice with that. But truthfully to me, you're not helping your case right now. You're just not. I mean, our decision is whether or not we believe there's sufficient reason to believe that a violation of state, I guess we wouldn't get to federal law, state election code was committed. I have different feelings personally on some of these. We'll do this as a board. a required disclaimer is state law. I mean, we don't have an option with that. If it's not there, it's not there. Okay, I mean, and the fact that some guy that printed it said this is a legal thing, if it's not legal, it's not legal.
Mr. Chair.
So go ahead.
Mr. Chair, and I want to be clear that I understood at the beginning that if we have questions for him, that does not count against his 10 minutes. So we could now ask questions and he could respond, and that would not be against 10 minutes.
That is correct.
So I
Go ahead, if you have a question, ask.
one
Yeah.
question, and I don't want to belabor some of these, but for the instance where you've clearly brought saying that you were doing landscaping, number one, I'm hopeful that you know that my office is not responsible for the groundskeeping of Election Central, but number two, I checked with my election supervisor during the recess to confirm we never received a complaint that there was any kind of impediment to voters accessing Election Central and the early voting site. We never received a complaint that you couldn't get into the door. As you have alluded to in another public meeting, I was there every day, more than once some days, and I never had an impediment getting into the building. I never received a complaint. My office never received a complaint. And I want to ask you directly, did you make a complaint to someone about the landscaping prior to utilizing the evidence you've presented to us today?
I'm sorry, your question was?
I never received a complaint. I am not aware of anyone in my office ever receiving a complaint that there were landscaping issues, because I could have made a call to the people that are responsible for the groundskeeping. I never received a complaint. I'm asking, did you make a complaint to anyone? Because as you know, I take very seriously your inference that voters had impediment issues getting into and accessing the early voting site. Did you make a complaint to anyone? Because I did not get one.
Yes, I wouldn't call it a complaint. I addressed the landscaping concerns with Richard Kreider, who is in charge of fleet and the buildings for the county, and also spoke with the young gentleman who takes care of the landscape there. Typically, I just spoke with Richard Kreider yesterday, again, about this. And at that time, normally, the county, Richard has Nature's Way do ongoing landscape maintenance at all. But because of the construction that had taken place, and there was the new hardscaping, I don't know if you've seen the parking lot, it looks awesome. I mean, I cleaned up so much gravel and debris there where it was unsafe for the handicap parking. But I worked with the young gentleman who did the mowing, and I helped him sweep back the grass clippings, and after the storms, brought down branches, and they were hanging into the way. Then I asked the young gentleman again if he could prune that, and then Richard came by, and he snapped off a branch to get it out of the way. But he snapped it off. He didn't cut it. So I told him that I would come back and make a clean cut with my loppers so that the branch would heal, instead of having a splintered end. And so then that next morning I did come back at about 7:40, and I pruned out those a few dead branches and things like that, and then was sweeping up then. So I just wanted to, that was I just bring this up because I didn't feel that it was necessary to contact your office to maintain the area of around the building. That's not your responsibility. I contacted Richard Kreider directly. He's the man who sends out the directives. Then that's the reason why. And And so, you know, like one of so I bring this up because in one of the videos that was presented, in which alleges that I was in the chute, you know, electioneering, I'm clearly just walking with my broom and sweeping, and I wanted to show why I had these tools with me all the time, trying to make it safe.
Molly, does the Indiana code about electioneering inside the chute say a candidate is not allowed to be inside the chute unless they are cleaning the sidewalk? And my point being, if it says you can't be in there, doesn't say it says you can't be in there.
It said,
End of story. If you can't be in there, you can't be in there.
the law.
That's why I'm asking.
The law itself
I'm
says-
asking our attorney.
There are 3 separate statutes that I think are applicable to the chute. The first one is Indiana Code 314-316, which does involve electioneering within 50 feet of the polls. Electioneering by statute means a verbal statement displaying a written statement or indicating support or opposition to a candidate, political party, or public question appearing on the ballot, or wearing or displaying an article of clothing, sign, button, or placard that states the candidate's name. And then it lists out what constitutes electioneering. And it says, a person who knowingly does any electioneering on election day within the polls or the chute before election day within the office of the circuit court clerk or a satellite office of the court 50 feet of the entrance to the office, except for a voter who is, and then it lists out exceptions, and that would be a Class 8 misdemeanor. So no, you cannot electioneer in the chute. However, there are 2 other separate statutes that pertain to presence in the chute. So Indiana Code 314-315 is entitled Unauthorized Person Entering into or Remaining Near the Polls. A person not authorized by this title who recklessly enters the polls, enters within the railing leading from the challenge window or door to the entrance of the polls without having been passed by the challengers or having been sworn in, or remains within the polls or within the chute in violation of 311-815, 311-816, commits a Class C infraction. And then there's language on how it gets enhanced to a misdemeanor. And then Indiana Code 311-816 is entitled Persons Allowed in and Around Poll Chutes. A person may not remain within a distance equal to the length of the chute, as defined by Indiana Code, of the entrance of the polls, except for the purpose of offering to vote. And so there are statutes that pertain to electioneering in the chute, but there are separate statutes that pertain to presence in the chute alone.
Okay.
So,
Go ahead, ma'am.
Mr. Chair, my point being, as the board may recall, Mr. Kreider was coming to regular election board meetings and offering updates for what was going on with respect to getting Election Central ready for early voting. He was very thorough, very competent, and I never once recall his saying that there were landscaping issues and groundskeeping issues that would hinder a voter's ability to access. Again, I was there every day, sometimes more than once per day, and I did not observe anything like that. It also concerns me that anyone would take it upon themselves rather than report the concern, would take it upon themselves, because that would bring liability. They could have gotten hurt, and then the county would have been liable for them getting hurt on county property. So that's my point about that, and I know that you want to move on, and I have no issue.
Kylie, did you get some of our early voting workers, let's just nicely say have been around the sun a few times. Did any of them give you any complaints about it being difficult to get into work?
No.
0?
No.
Okay.
I would like to add that's because I took care of business.
Point noted.
Mr. Chair?
Okay, yes, ma'am.
At this point, I would like to suggest that we close the hearing on this complaint and hold our board deliberations so that we second complaint.
I would like to make a motion.
No,
You're
sorry,
not
no,
in a
sorry.
position to.
Had somebody else?
I don't like to be in exclusive clubs very often, but this is an exclusive club of 3 right now. I'll second that we discuss and then decide where to go. Ashley, would you call the roll since this is what we're doing, please?
Thank you.
Okay. Ashley, go ahead.
Nicole Brown,
Yes.
Danny Shields,
Yes.
Penny Gibbons.
Yes.
Okay, so, again, to clarify what we're doing, we decide whether or not we believe there is sufficient evidence that a law may have been violated, and should we move it to an investigative body to make a decision as to whether or not they think charges should be filed. Is that succinct enough?
I think I can simplify. Looking at IC 36531, the board can, one, take no action on the complaint if you believe that in this case Ms. Wheeler did not prove her allegations. You could forward it to the prosecutor, who then inevitably will forward it to the state police, I believe. So you could just say forward it to the prosecutor, or you could issue an admonishment to the candidate and do nothing further. The statute is really broad. In the language, it says take the action the board considers appropriate under the circumstances.
Might I suggest we do one at a time?
I was thinking so, yeah. That was my thought was one at a time. I mean,
So, do you want me to read the first one?
well,
Or
do you have any thoughts before we go into that, ma'am?
I'll save them until we get to each.
Okay,
I think
okay.
it's appropriate.
Well, we've all got them, so, in my view, we do have enough to move on with the disclaimer on the signs, just because I don't think it meets the code.
I'm sorry,
The disclaimer on the signs, I don't believe, I question whether it meets the code. And I would like someone else to make that determination, someone who makes that on their own.
Jeremy at White Rabbit said that you could talk to him.
Jeremy at White Rabbit does not make this decision. The prosecutor or the state police will make this decision.
And I would especially.
He may be a wonderful person. I have no idea.
I would especially like to.
I would like to,
It's not your turn to talk, sir. I would especially like for it to be pointed out that both sides of a sign must have that disclaimer if they are presented to the public. And as I look at the sign, the table there right now that says write in Joe Davis, there's no disclaimer on the side that says write in Joe Davis. So I hope that excuse me, sir, I'm speaking. I would like to put it on record that we ask that whomever reviews this, review that specific sign for its
So is that, well, okay.
When we've had sign complaints, when the previous incarnations of the election board have had sign complaints, the candidate was given an opportunity to put the disclaimer on there. It appears to me that that's what he is saying that he did. Can you turn your sign around? Her point is that it's not on both sides. I see this. Can you turn it around to see if we can see if you put it on both sides?
Can we see the back side of that sign, please?
this sign, I removed the old stickers because the rain was on there. I just put new stickers and see how this is updated? This is an example of
That's what we're asking to see is the back side of the sign.
I didn't want to cover this up so that you could
Okay.
see what it looked like before. That's all. This sign wasn't at early
This was
voting.
not, okay, but
This is an example. I brought this in as an example.
so your contention is that both sides of any sign that was at Election Central had this on each side?
If it was a sign that was going to be visible from both the front and the back, yes, I did do both sides. I only brought this today as an example of what it looked like. But all my other signs, after all the rain, the paper came off, and I slowly replaced them. Signs in. I started to replace them. And
Now,
put them
Is that the one under the QR code that says paid for by Joe?
Yes.
Okay, now for me, and I'm a woman getting older by the day, the paid for by Joe does not appear to be something that would stand out so that you could distinguish it. You have to be able to read that. And so me walking by that sign to go in and vote, I would not be clear that it was paid for by Joe. Unlike, this is very visible.
Yeah.
But do you see my point under your QR code?
Yeah, yes, but it is much larger than 12 point. The law says that it needs to be 12 point, or it says that it can be 7 point if there's high contrast between the background color and the new color.
And I'm
So
saying I don't see the high contrast.
that's, well, okay, that's why I say I took both. I can show you, if you put this right next to the paid for by Joe, the font size is exactly the same.
I'm not disputing the font size.
Well, what I'm trying to say is this is much larger font technically than what the state law requires. If you look at other candidate signs, they're paid for by the committee to elect whatever. It's very, very small, very small.
If I may,
But the thing is, nobody filed a complaint against their sign, so that's a point that's,
But also
That's a
election
moot
law,
point right now.
election law says that the contrast has to occur.
That was
if I
my-
may,
Yes.
board, the hearing was closed at this point, so this is board deliberation, so I don't know if
yeah, you're right, thank you.
reopening the
That's
hearing.
5 minutes ago.
Sorry,
You should have done
reopening.
this 5 minutes ago.
No.
Throw something at me if you need to.
Well, then my deliberation for the board, in the same way you could not put navy blue, a black background, because who would be able to differentiate or distinguish that, then I am concurring that there is at least some evidence that the statute for the required disclaimer have not been met.
I concur. I suggest that we forward that for,
So about, okay, are we doing just number one right now?
Yes.
So do we have a motion that we, now,
I think you can simplify it and do one motion and just identify that you would like to forward the complaint to the prosecutor and for.
numbers 1, 3, okay, fine, that works for me.
I think it's technically one complaint. She's just subcategories in it.
Okay, six numbers 1, 2, 3, okay.
So going forward, and it's either a yes or a no.
Okay.
And then they decide.
You mean on all 4 of them? I'm perfectly fine doing it, with doing all 4 at once.
Okay.
And so a motion would be,
If I can help.
should it go to the prosecutor or does it just go to the state police if we're going to move it forward?
I think you could make a motion to forward the complaint for further investigation to the prosecutor. And then if the prosecutor's office wishes to send it to the state police, which I believe they will, that would be their decision.
so moved.
Any other discussion?
I don't know if you caught that, Ashley, but the clerk seconded it. Her mic didn't light up. That's the only reason I said that.
So, yeah, Ashley, would you call the roll? Let me make sure what we're voting on. We are voting to send the complaint to the prosecutor's office to determine whether or not the prosecutor wants to send it on to the appropriate authority, most likely the state police.
Yes, that would be.
That's what our motion is.
Second.
Okay, now Ashley, please.
Nicole Brown,
Yes.
Danny Shields,
Yes.
Penny Giddens,
Yes.
Okay, so now we will open second one with Ms. McGarry. So, yeah. Oh, yes, so we're gonna let,
So the hearing regarding the complaint from Ms. McGarry is now opened by the chair. We received an email, to summarize this complaint, an email correspondence was received. I'm trying to look up the date, but an email correspondence was provided containing a written note by Ms. McGarry, and the note indicates that Ms. McGarry came to vote on April 30th about 1:15 p.m., and she had walked from the handicap space in the lot and was approached as I reached the corner of the building. I was approached by candidate for clerk, Joe Davis, who talked quickly and at length, and I tried to continue walking. I'm sorry, Ms. McGarry, I am having difficulty reading your handwriting, and that's a total me issue.
would you like me to do that? I made a living reading this kind of handwriting.
I mean, I don't even know if you want to read the complaint. In essence, we received the complaint. The board has received the copy of the complaint. Mr. Davis has received a copy of the complaint, and the complaint details Ms. McGarry's interaction with Mr. Davis.
She's here.
Unless you have questions on that summary, procedurally, we can move to having the complainant offer testimony.
I think that's a great idea.
Before I administer an oath to Ms. McGarry, is it easier for you to offer testimony from there without standing at the podium? Well, we're going to need you to pick it up on mic, but I can make this easier. Look, it's moving. Okay. Ms. McGarry, do you swear or affirm that the testimony you're about to provide to the board will be truthful?
Yes, I do. So do you want me to repeat what I wrote?
I don't know necessarily repeating it is needed. I would just, since you've told us in your own words what happened, would you just elaborate a little bit for us?
I would be glad to. He approached me after I got out of my car. I parked in the handicapped.
This is prior to voting.
Prior to voting.
Thank you.
And I felt like he latched himself onto me, was telling me his background and telling me a lot of terrible things about the clerk's office and why it needed new blood and so forth. And I kept saying, I don't want to talk to you. But he followed me around the corner toward the entrance to the building. And I finally somehow got disconnected. And he immediately went over to a tall man standing there and started to talk to him. And that man turned his back to him. And he went to a shorter man in a little polo shirt and started talking to him. So he was talking to him when I walked into the building. As soon as I walked into the building, I made a complaint because I felt trapped. I felt it was inappropriate to be on my way. I think she called it the shoot. And being approached so, well,
But you're not,
insistently by a candidate. So after I voted, and I was told a lot of people were complaining, they weren't sure what they could do about it. But I voted. And before I left, she asked if I would mind writing a statement. And the statement, as was read, I was voting at the end of early voting, so a lot of your conversation was what was going on at the beginning. But when I left the building after writing my statement, got in my car and drove to the exit to the street, he was still talking to the same short man in the polo shirt. Clearly, the man wanted him to talk to him, but I still felt it's right outside the steps to the building, and he was saying the things to this man that he was saying to me. It was definitely electioneering.
Are you asserting it was inside the chute area? Do you remember seeing where the chute was marked off?
The chute was not marked off, as far as I could tell, but this was within 2 feet of the steps into the building.
You feel intimidated by Mr. Davis?
Very much. I felt trapped. I'm a regular voter. I used to be a poll worker. So this was just something I had never seen or experienced before.
May I just clarify, 2 feet from you left your car, you walked toward the east entrance of Election Central,
Yes.
2 feet of the door or 2 feet from the curb? Do you see what I'm saying?
He approached me in the park while I was still beside the parking lot and walked with me till the point where I turned the corner of the building to go up the steps.
Turn the corner of the building.
So, like I said, the chute was not marked, but so I don't know where the chute was or
Well,
wasn't.
unless it was raining, had rained up, the marks, that the chute was marked
Correct.
every day. So it may have been, that would indicate to me that probably it was for what we would consider the chute area.
Where did the chute start?
50 feet from the door, basically when you came out of,
He was talking to me well within 50 feet of the door.
So, because the candidates are outside of the 50 feet.
Yes.
So you're saying that when
He
he
was
was speaking with
inside the
you, you had
50.
passed all of the other candidates running for office?
I didn't see any other candidates running for
The day
office.
that you had, the day that you came, there were
No.
no other candidates?
And I didn't see any other signs.
The
But I
signs
came
are
from
also
the
50
parking
feet
lot.
out.
Signs may have been along the street. I don't
They-
know.
They're both wait, but so the signs would, so you're saying I didn't see any signs, I didn't see any people,
Except him.
except him? Then, so for me, I'm trying to figure out how close she was to the
to the
door.
door at the time.
And it sounds to me like you're saying you were closer to the door than not.
If he's saying 50 feet is the chute, I was well within 50 feet.
The chute started, Kylie, correct me, roughly 10 or 12 feet from the actual door to the building? Because we had that space, that inner space.
Okay.
So it would have been 50 feet from the door. I would say it was probably 10 feet from the edge of the curb to where that 50-foot line would have
Okay,
started.
But let's also be clear, there were some signs that we were authorized to have there, the directional signs.
Correct.
And that had been a whole thing where we
There
ended up
was.
meeting with this.
There was to the left. I don't know how to describe it. It looked like a flower cart or something.
Okay, so were you closer to the door than the flower cart? Because I remember that.
Yes.
So closer to the door than the flower
Yes.
cart would be within the 50 feet.
We all
And there
remember, we
was
remember the flower.
a blonde lady by the flower cart. I don't know who she was.
We've got a timer, we've done our 10 minutes, correct? Okay, all right, yeah.
No.
Oh, we haven't? Okay, you started.
Yeah, I started a timer,
Because
sorry.
that's time,
Oh,
that's
okay.
climbing up.
I do have another question for Ms. McGarry, but also thank you for, in the past, working as a poll worker. It's appreciated by all of us, I am sure. Did you feel like Mr. Davis impeded you from actually even exiting your vehicle?
No. He came toward me after I got out of my car. But that was, the handicap spaces were certainly not within what you're calling the chute.
Correct, yeah.
For me, I'm more concerned about the potential for voter intimidation than I am for whether or not it was actually inside the chute.
And I'm in agreement with you on that.
Is there anything else you
Anything
want
else you want to add?
No.
Okay, then if start Mr. Davis's 10 minutes.
Before we
Oh, sorry, go ahead. It's not started yet.
Before we do that, Ms. Ferris did provide testimony just during that hearing, so I'm just going to ask her, was the oath that you were previously administered in the first hearing, were you adhering to that oath during this hearing?
Yes.
All right. Mr. Davis, I'm going to ask you the same question. At the previous hearing, you were administered an oath to tell the truth. Do you swear or affirm you're going to adhere to that oath during this hearing as well?
Yes, I do I'll continue to swear to tell the truth.
Thank you.
It's a perjury.
Okay, so please start his
And
10.
before we start the timer, do you still want the same 5, 3, 1, 30-second warning?
Well, I would like to be able to address some questions toward Ms. McGarry, if I may. No, because, well, one thing...
Doing cross-examining here. You have 10 minutes when we start the clock to state your side of the issue.
There's a... well, first, I think it's important that we first recognize which handicapped parking spots Ms. McGarry was at, because there were handicapped parking spots that were on Morton Street itself, but there were some handicapped parking spots that were in the parking lot. So that might help clear up.
We're not being accused of being in the chute electioneering in this complaint. So which parking spaces it happened to be really wouldn't seem to matter. The complaint is that you were annoying, which is not illegal, but were just somewhat intimidating to someone in the parking lot who was attempting to vote. Is that a correct assumption? And that, yeah, and we understand that. That's not, you know. Okay, all right. Are you ready?
All right. Mr. Davis, do you want the 5, 3, 1 minute, 30-second warning? When your timer
yes,
starts.
please.
Okay. All right. And then TSD is putting the timer up now. And
There goes.
you may begin.
Okay. The 30th was Thursday. This was the last. This was the Thursday before voting would take place on the following Tuesday. So, I'm very sorry, Ms. McGarry, if you felt intimidated by my approaching the voters on that day. But voters were coming fast and furious. It was all I could do to look out and see which groups of people were walking from the parking lot area. And so I would go and approach those people. Hello, are you here to vote? May I please introduce myself? My name is Joe Davis, and I'm running for county clerk for the circuit court. As a practicing jurist at law, I filed into or been a witness in half of the courtrooms in the Justice Building. I filed into Owen and Greene County courts. As I filed through both online and in person, I've seen where the blind spots are. I've seen where small mistakes compound and then are quite burdensome to remove. So therefore, as clerk, I will put into place measures, checks, systems to guarantee greater accuracy in the filings. And I will also institute an outgoing email and text message to anyone who comes in to make a filing or make a payment. And the simple message will say, hey, please double check your filing for accuracy, because if we get everything taken care of, the courts, the clerk's office, and life for the Monroe County voter will be much more efficient. That was basically my message, and I whipped through that so many times. I know that I wasn't saying anything negative about the clerk's office. I was just saying that I was going to ensure greater accuracy. And I told this over and over and over again to voters as they came through the entire period. And at that time, I had it down to like 20 seconds, 25 seconds, boom, boom, boom. And then I moved on to the next person. So I'm very sorry I was speaking so quickly at that time, but I was trying to get my message out, and it was very simple. And then I would move on to the next person. So I'm very sorry. Some of those other people who I talked with, as you mentioned, the man in the polo shirt, he enjoyed to talk with me so much that we continued to talk. And that doesn't mean that I was annoying to other people. Some people were very engaged. I'm so sorry. Out of maybe speaking with 1,000 people, you were the one person who complained. I would like to know who asked you to make this statement. That would be very informative. Who asked you to make that statement?
Sir, you're not allowed to talk to her.
And probably,
to us, gee, you hope somebody would send that
probably Tree Martin Lucas was the person near my flower cart, because at that time she was setting up her chair right next to it. So the blonde-haired person was probably Tree. But at any rate, I approached many voters. I did not speak negatively about the clerk's office. I spoke only how I had a plan to improve it, and that was my message. It was simple, and that's why I got 21% of the vote. Again, I am so sorry that you were intimidated. I apologize for that. I have learned, this was my first primary, I have learned a lot about reading
eyes here
people.
or there.
Okay.
Here or there.
So I am very sorry if I was annoying. 999 people were not annoyed. Next year, next election, I'm going to make sure 100% of the people are not annoyed. And if they are annoyed, I'm going to personally apologize to them and try to figure out how I can serve them better. So how are we doing on time?
You're at 5 minutes and 41 seconds.
Okay. All right. So I think that that complaint, sure, it is valid. But this seems like it was gathered up by this, I'm going to call them the whisper cabal, which again was Penny Githens, Tree Martin Lucas, Karen Wheeler. All of these whisperers were just looking for any excuse they could to make a complaint about me, because I was a successful forward candidate. As we moved toward the end of the early voting period, I was catching up to Tree Martin Lucas. I was getting those votes. If early voting went on for another month, I don't know, maybe I would have caught up all the way. But essentially, I am about service. That's why I run as a candidate, because I'm trying to improve the situation wherever I go. Wherever I go, I know things can be improved. And I'm very sorry if sometimes toes get stepped on, but change happens when people act, when they make change. Things don't change when people sit on their hands. So sometimes change makers feel threatening to people, but that's okay, because it takes all of us to make the world go round. It takes all of us. So the question that one must ask is, why why am I being singled out in this manner? And that is because I believe, in my opinion, that this was supposed to be a redemption election tour for Tree Martin Lucas and Karen Wheeler. We all know about how 4 years ago there were 6,600 votes that were not included, the last week's early voting, not included in the vote total. And Karen ended up resigning, and Tree Martin Lucas resigned in support, or I don't know.
Minutes.
But this happened. And as a candidate, if I were elected, I was going to ask Tree and Karen whatever job they wanted, they could have it in my administration, because I felt bad for them for that mishap. You know, it was an honest mistake, I feel. Some people said maybe it was nefarious, but I feel it was an honest mistake, you know, and I believe that it's because I started to all of a sudden seem like a true candidate that the whispering cabal started to grow desperate, and they started to speak amongst themselves. What can we do to bring this guy down? Like the election signs. I mean, the disclaimer, I mean, the paid for by Joe was fine the previous election. I don't know why it's being investigated again when it was okay before. But, you know, that's okay, all right? I am still an independent candidate collecting signatures to get on the ballot for the fall as clerk. And again, I'm going to speak to the voters. I'm going to make sure that the early voting area is up to snuff and safe for everyone. And Richard Kreider is going to make sure that whatever my volunteer ad or value add is going to fit in with the plan, because they are so understaffed over there and they need more people than the county affords them. And they need all the volunteer help they can get. So again, you know, I think what this comes down to is that this was supposed to be a redemption election for Tree Martin Lucas and Karen Wheeler, and someone told me that Penny Githens was going to get a good job in the
30
office
seconds.
too. So that's all fine and dandy. I want everyone to do the best job they can, but should I become the new clerk in the fall following the election, I'm going to again ask Tree, whatever job you want, Karen Wheeler, whatever job you want, because I know you'll do good work for the people, because you have before and you will continue to do so. All hands on deck.
Thank you, sir. I feel bad not asking this question. Indiana has a sore loser law, correct?
Yes.
And if that's the case, if you ran for clerk in a primary and did not win, you are not allowed to file as an independent for that same office in that general election.
People bring up the sore winner law. I've heard this, yeah, the sore winner law establishes, well, tries to eliminate independents from getting on the ballot.
Or loser law.
It's called the sore loser law is the name of it. I'm just.
Some people refer to it as the sore winner law.
Fine, tomato, tomato, that's not, doesn't matter. You make your, you go ahead, but I think you're gonna end up not being happy with the result of how that whole thing works. All right. We need to move to deliberations, correct?
Procedurally, is the board closing the hearing at this time?
Yes.
I move that we close the hearing at
Yes.
this time.
Okay.
Second.
That you can voice vote. All in favor of closing the hearing?
Aye. Sorry, Ashley, we'll come back to you later.
So if we are closed, I'm just going to quote the 4 words direct from Mr. Davis. This
I agree, and as soon as we're finished with deliberation or discussion, I would be happy to make a.
I'm
Okay.
finished.
Okay. My question, and this is a legal thing, okay? Where, is there a reasonably solid line, or is it wavy and curvy between being annoying and being intimidating and threatening? You follow where I'm going? I mean,
I understand the question.
is one thing, threatening people or intimidating them is something else.
I'm going to try to look up the voter.
Am I making sense to you guys?
Yeah, I think it's whether or not there was interference with somebody trying to get into the
To get
poll.
in to vote. I don't disagree with you there. Right, I see that. And this may be a thing that life experiences for you guys and me are different here. So that may be, I'm looking at it from a different point of
understand.
view.
I appreciate that, yeah.
Okay, I mean, I get that.
While that's going on, may I ask Ms. Veras one question? I think that I heard you say this, but I'm not 100% sure, that you did have that you had complaints from other voters about some of the behavior.
Yeah, so there were multiple complaints that were made to our office. Actually, in fact, this one, once we started getting more and more, I was requesting individuals to write them down. I do remember that Ms. McGarry was brought into my office, and I asked her to write the statement down on writing so that I could then send it on to the election board so we could continue making progress with this, as after the first couple of conversations, behaviors and actions were not changing.
May I address that response?
I don't think that, as much as you'd want, I don't think that's appropriate right now because we're in our deliberations. Again, this is that currently exclusive club of 3. You're still looking, correct?
It's one of those statutes that cross-references other statutes, so I promise I'm getting there, I think. I think it says a person who knowingly or intentionally intimidates, threatens, or coerces an individual for voting or attempting to vote, urging or aiding another individual to vote or attempt to vote, or exercising any power or duty under this title, commits voter intimidation. But then you have to go and look what constitutes intimidates,
Where
threats, or
I'm
coerce.
kind of arguing with myself right now is you might feel intimidating to someone while you yourself don't feel you are being that. Yeah, but I am probably more inclined, since the prosecutor's going to look at the other ones anyway, she could look at this and say, hey, you guys are weird, and throw it, or there's something here.
I think she has a lot more experience with this kind of
Absolutely,
terminology than I
absolutely.
certainly do.
Absolutely. So, whenever.
I do think it's a fact-sensitive inquiry.
Okay.
Would you like a motion, sir?
I guess we would need a motion, yeah.
I move that we forward Ms. McGarry's complaint to the prosecutor for further.
Okay, any other discussion? No. Ms. Ashley?
Nicole Brown,
Yes.
Danny Shields,
Yes.
Penny Giddens,
Yes.
Okay, so I think now that we've made those motions, that your office does send this forward.
I will forward the complaints to the prosecutor's office. However, I do have a procedural question. I will provide the complaints and any evidence that the board received from the complainants. Now, Mr. Davis did present evidence, and he has had the exhibit that you presented. Are you okay if I take pictures of this and send it along, or I don't know how to capture your exhibits here? I'm assuming you don't want to leave them here, and I don't want you to either. So I would like to just take photos if the boards are okay with that and Mr. Davis is okay with that.
Absolutely, yeah, that's
Okay.
absolutely fine.
Okay, because
And
I assume you're going to need those things.
Yeah, I will. I'll especially need the tools to continue to clean up
Okay.
for the
We
early
can do
voting in
that.
the fall.
All right. So I will work with Mr. Davis on getting photos to send to the prosecutor as well of the exhibits that he attached. And then I think that brings you back to the election board agenda.
which would be,
Public comment.
is it appropriate for me to ask for public comment that would be germane to what we've been working on since the fact is that we've had quite a meeting and people have to go back to work? Or do we have to take public comment at this time? Was it posted on the agenda?
It was not posted on the agenda, and that is an error on my part. We do normally have public comment at the election board meetings, but for clarity, the public comment would be not on the
okay,
hearings.
I understand. Pleasure of you, board members?
I'm fine knowing that people are limited to 3 minutes.
Okay, 3 minutes. There's public comment for 3 minutes.
Mr. Davis, for clarity, are you providing public comment at the current time?
I'm sorry.
Are you providing public comment? We moved on, we've closed all the hearings and we moved on to public comment.
Here, I'll move my stuff out of the way for public comment then.
We were just trying to figure out if you were commenting or not, but it sounds like the floor is.
And what would the public comment on anything having to do with elections? Is that what we're?
Yes.
I mean, just anything in general? Is that what?
Well, we'd like it to be election related. We have someone in line who would like to speak.
I need to get the clock restarted.
Restart the clock, please.
Well,
Thank
could
you.
stop for a second, don't start it yet. Am I supposed to sign something?
We'll deal with that.
Oh, I just wanted to make sure, I didn't want my time to get ticked away because I'm still waiting to figure out what's happening here. I appreciate it. Cheryl Langdon, Monroe County taxpayer. This is all about how our elections are pretty polarized. We need to have a conversation in the U.S. An 18-year-old unarmed, alone Henry Novick was attacked in England 6 months ago. His assailant's brother called 911 and made a baseless claim that Novak racially attacked him. When the police arrived, unarmed Henry was found dying of his stab wounds. Henry had said, "I have been stabbed." The attending police officer gaslit the dying victim, saying, "I don't think so, mate." Henry received no medical attention until it was clear that he was dying, and by that time it was too late. He was dying in handcuffs and was a victim of a racist attack. No one wants to admit this, but his attacker, a Sikh man, falsely accused Henry of a racist attack against him by Henry that night, which misled police to treat unarmed Henry as an assailant rather than a victim. The left refused to acknowledge Henry's victimization that occurred twice. Why? Because the victim is white. The reason it's important to talk about the invasions that progressives created in European nations like the UK and the United States is because our nation's white citizens are being discriminated against for absolutely no reason. In August of 2022, Brittany Farr released an essay on the University of Chicago Law website, Fears of a Majority Minority Future Depreciating Value of Whiteness. Her essay failed to acknowledge the violence against innocent white people all over the world. And in the United States, law enforcement reports have also documented an increase in anti-white hate crimes during several recent reporting cycles, sometimes accounting for upwards of 10 to 20% of reported race-based incidents. New York City's Mayor Mandani continues to use racially charged language against white citizens concerning tax increases, quote, richer and whiter neighborhoods, unquote. The mayor continues to use racially charged language against white people in his administration. It's amazing to me how non-white and white leftists are allowed to be openly racist as long as it's against white people. This must stop. Innocent white people are being targeted, assaulted, and many times murdered for being white. The funding of hate groups by leftists has been exposed. It's not right-wing Republicans who are choosing hate. Conservatives are just responding to the radical terrorists and invaders' violence against white Christian people. Both non-white and white leftist progressive politicians have been provoking race hate. We have been thrown to the wolves by our own countrymen. They have openly betrayed us, and I say shame on every Democrat. You have helped create a race-religious war. You have put a target on us all. Thank you.
Thank you. Any other? And I will make a motion to it. Oh, it's becoming, okay. Go ahead, sir. Your 3 minutes will start. Whenever they put it up there. There it is. Your time is running.
3 minutes.
3 minutes.
Okay. Can you please let me know 1 minute and 30 and then 30 seconds? Thank you. I would like to ask that the election board look into instituting more transparency with procedures like the one that we had today. To make contact, if there's an agenda that goes out, that it's sent to the person who has to come before the hearing body. That these things are done days in advance so that one can prepare. Had I known that there was going to be just like lickety-split limitations on time placed today, then I would have been preparing a presentation or argument that would be totally different from what I did, word to word, because I didn't know any of the rules. I mean, 2 complaints submitted to me at one time. It seemed like I was to address them both, but it never said that I was to address them individually, and that each one would have 10 minutes. It was never explained that I couldn't speak to the other witnesses or ask any about the evidence that was being submitted, who took it, why, and sure, we're going to move on to the prosecutor, and I welcome this opportunity, because then we'll go forward and we'll hammer things out which will improve the system. That's the way it's going to work out. I'm going to be vindicated. It's going to waste a lot of time for everyone involved, but I will be vindicated, and you will learn new procedures. And hopefully in the future, no one will be so rudely dealt with like I've been dealt with today. And but that's okay. We all can improve. I know that every one of us in here tries to improve every day. So let's make this a civil environment, and let's make it transparent. Let's give everyone the full disclosure possible. This will be the best for everyone. Thank you very much.
Thank you. Prior to adjourning, the clerk brought to my attention that our next meeting is July 2nd. and that the commissioners may not meet that day.
I said if they did.
If they did, oh, I'm sorry, I thought you heard that. If the commissioners choose not to meet on July 2nd, what would your pleasure be on us meeting in the morning instead of later in the afternoon on that day, since this room should already be available?
I believe there will be a commissioner meeting on July 2nd. They've canceled the June meetings, but July is still scheduled normally.
Okay. We can follow through as to whether we actually need a meeting on that date, being that close to Independence Day.
As long as we give notice, we can cancel that meeting.
Okay, we'll communicate that through your office. Okay? All right, then I would entertain a motion to adjourn.
Motion to adjourn.
Second?
Those in favor, aye? Aye. Opposed? Happy June.
Thank you.